And if the others of you wouldn't mind turning off your video until I call you back, there are a lot of folks here this afternoon. It's hard for me to find who I'm looking for. Thank you. All right. Mr. Evans, do you want to get us started?
Sure. Thank you, Your Honor. I represent Mark and Cassandra Stancic on behalf of their daughter, Francesca. Francesca was injured at her school. She's a little one. She was born in 2016. She was injured at her school. In 2022, I filed a lawsuit on behalf of her family and her. And Mr. Thompson and I have been able to work together and work this case out. And so we're here just to prove it up. And I think Mr. DeShazo has graciously volunteered to answer the question or to ask the questions for us today.
All right.
Yeah, sure. I'm ready when you are, Judge.
Go ahead, Mr. DeShazo. It's yours.
Mr. Stanzik, would you state your name, please?
Oh, wait a second. Let me do this part first. Mr. Stanzik, do you swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead.
Could you state your name, please, sir?
Merrick Stanzik.
Okay, Mr. Stanzik, I'm Scott DeShazo. I've been appointed as guardian ad litem in this case for your daughter, Francesca. Do you understand who I am and what my role is?
Yes, I do.
Okay. And your daughter was injured in an incident at her school, the International School of Texas, back on May the 4th of 2022. Is that right?
Yes.
And she was injured on the playground at school. Is that true?
Yes.
And as a result of that injury, you and your wife made a claim on her behalf against the school for alleging negligence, among other causes of action. Is that right?
Yes, that's correct.
Okay. And you have agreed to settle that case. Is that right?
Yes.
Now, your daughter's injuries were fractured wrists, true?
Yes.
And have those injuries healed?
Yes.
Okay. Have the medical bills been paid?
Yes. Yes.
Okay. And is your daughter back to full activity after this injury?
Yes.
Okay. She was about 6 years old when it happened, and now she's about 8. Is that right?
Yes.
Okay. You understand that you don't have to settle this case if you don't want to, but by agreeing to settle it, that you're foregoing your opportunity to go to a jury trial.
Yes.
My understanding is that the total settlement is $20,000, and a little over $12,000 is going to be placed into the registry of the court bank account. Is that right?
Yes.
You understand that you won't be able to get to that money.
Yep.
All right. You understand that when your daughter turns 18, she's going to be able to go and get all of that money out herself.
Yes.
Okay. Do you believe that your daughter's going to have any future medical treatment as a result of these injuries?
I don't believe so.
Okay. Do you understand by settling this case that you will not be able to bring any further claims against the International School of Texas as a result of this incident?
Yes.
And knowing all this, Mr. Stanzik, do you believe that the settlement is in the best interest of your daughter, Francesca?
I do.
All right, very good. Thank you, sir. I'll pass the witness.
All right. Anyone else?
I have a couple.
Go ahead.
Merrick, we went over the breakdown of the fees and expenses a few days ago, correct?
Yes.
And from this settlement, $12,063.89 will be deposited in the registry of the court, interest bearing for Francesca. You understand that, right?
Yes.
And our fee was 1/3, which was what we agreed upon way back in the day, correct?
Yes.
And the expenses in the case were $1,269.44, which you deemed to be reasonable in light of what we did.
Yes.
Okay. Have you been happy with our representation of you?
Absolutely.
Thank you. I'll pass the witness.
Mr. Thompson, do you have anything?
I don't have anything, Your Honor.
All right. Thank you, Mr. Stanzik. I appreciate your time and your testimony. I don't have anything else, counsel.
The only thing, I'm sorry, Judge, the only thing I would say is that if Mr. Thompson would like Cassandra Stancic to ratify everything her husband just said, it's totally up to you, Cole, if you want to do that.
Oh,
she's
sure.
here.
I mean, I guess she's a party to the lawsuit. I don't know if it's necessary or not. If we have Mr. Chancic talking, but
up to you, man.
If she wants to just jump on and say she agrees with everything he testified to, that's fine.
All right, let me swear her in. Ms. Stanzik, if you will raise your right hand, do you swear or affirm the testimony you will give in this court will be the truth, the whole truth, and nothing but the truth.
I do, yes.
Go ahead,
And
please.
I'll do this one real quick, Cole, if you don't mind. Would you please state your name for the record?
Cassandra Stanzik,
And you're the mother of Francesca Stanzik, right?
yes,
You've been present throughout this entire Zoom hearing and heard everything your husband just testified to, right?
yes,
You agree with all of it?
yes.
Thank you. Pass the witness.
Anyone else have anything for Ms. Stanzik?
No, Your Honor.
No, Your Honor.
Okay. Having heard the testimony in this case this afternoon, I will approve the proposed settlement. And I don't have any questions for you. And Mr. DeShazo is to be paid $1,500 by defendant.
That's correct, Your Honor.
Okay. All right. Well, glad to hear that your daughter's made a full recovery, and best wishes to you. Y'all are excused from the virtual courtroom.
Thank you.
you.
We'll get it signed. Thank you.
Yes, Your Honor. Carla Valley on behalf of DLJ Mortgage.
Okay, and Miss Valley, let me go ahead and interrupt you because both citations in the court's file are, quote, unexecuted.
Okay, so the citations are, this is 736. So under the 736, the service is completed at the time that the citations are placed with the mail in the mailbox.
Okay.
So personal service is not needed, just the service is complete at the time of mailing the citations.
All right, well, I'm gonna have to pull the statute. Normally we have actual citations that have been served and
Right,
when I look-
736 is the only one that has that
Okay.
exception on it.
Okay, and you have had no response from either the occupant or,
No, we have not heard anything from anybody living in the property, the borrower, no family members of the borrower, since this is a reverse mortgage. Nobody has contacted us on this loan.
all right, well, go ahead and lay out the motion then.
Okay, this is a default for taxes and insurance on a reverse mortgage. At the time that we filed the application, the borrower was delinquent roughly $5,600, and they have not paid anything. They have not responded, tried to contact the mortgage company. We have, like I said, the citations were sent on August 14th, and there has been no response filed. We did file a certificate of military affidavit and of last known address. And we are just requesting the order to allow us to proceed with the foreclosure.
Okay, all right, well, I'm gonna have to pull the statute. I haven't had anyone come in here and tell me they don't have to have service under this particular rule, so I just wanna double check what you're telling me before I sign off on anything.
I understand, Your Honor. Thank you.
Yeah, we'll do that. We'll take a closer look. And you've sent in the proposed default judgment.
Yes.
Okay. All right. If we have any additional questions, we'll reach out, but I don't think I have any for you at this time.
Okay.
Maybe excused.
Thank you. You have a good
Alright.
day.
You too.
Let's
Take care. Go to Liberty County Mutual versus Emerald. And I think y'all said no record, so.
Correct.
And Mr., is it Karamidas?
Yes, right.
It's your motion, right?
Correct. Yes.
Okay, go ahead.
Sure. This is a lawsuit that involves about $75,000 that Liberty Mutual paid to its insured because of a roof that was improperly worked on, and a leak occurred into a residence there locally. And so we've sued the contractor and the subcontractor. To this point, They haven't offered enough to where the case is settled. So we had a mediation scheduled. I showed up to the mediation after consulting with the client, and the other side didn't show up. We have two defendants. One showed up and one didn't. I sent an email to the attorney for the defendant that did not show, kind of later in the afternoon, and just asking why the no-show. I didn't get a reply, so I drafted the motion for sanctions and filed it, and then I did get a reply after that, after I had filed the motion. And so my client paid, almost $900 back in May to mediate the case. The mediation didn't happen, and it was really just a lack of response to, what's the deal? Why aren't you here? That I think caused more of a waste of time and confusion. And the response only coming after I filed the motion late in the afternoon was what the facts bore out.
Okay. Ms. Gleiser?
Good afternoon, Judge. I don't think this rises to a level of sanctions in this case. I personally never received notice of this mediation. My associate did, and she was the only one in my office that did. She was not aware that she was the only one who had received mediation or notice of the mediation. I have been taken off of emails during the scheduling of this mediation. I don't know whether that was on purpose or not. I'm not blame there, but I have been taken off of email, so I never got information related to the scheduling of this mediation. On the date of, I think it was September 5th that this mediation went forward, our office, specifically my associate, received an email from the mediator. That was Jeff Jury. And, I've mediated with Mr. Jury several times. I immediately picked up the phone and talked to him. I told him the situation. I told him that I had not received notice. And he understood, and I gave him our full settlement authority on that day. And he told me he was going to talk to the other side. I believe the latest thing about 10 minutes prior to plaintiff's motion for sanctions was Mr. Jury had emailed all of us saying he was going to continue working the phones and emails in order to try to help us out. Since that time, we've scheduled another mediation. So we have another one coming up in 2 weeks. In total, I know plaintiff is claiming about $3,000 in attorney's fees and mediation costs. I just don't think that they've met their burden. They've failed to show entitlement to those fees. We've tried to work with them. I think the miscommunications between what was coming across with the mediator at the same time that the other side was communicating with us, that is probably what went into the communication issue on the day of mediation. Like Mr. Karamita said, we did respond to his request asking why we did not show up to mediation that day. It just was not prior to his filing of the motion for continuance. So with that, we respectfully ask that you deny the motion for sanctions.
All right. Any final words?
Not really, Judge. It's just, I had my client there participating in the mediation with me, and the other side doesn't show, and the client's like, I paid, almost $900, and now we've basically spent 2 hours of time at the mediation, and so to the client, I want to say that there's some repercussion to doing that. I think that there is a mediation order in the case, and they didn't comply with it by not appearing, and I'd like to tell the client that something became of this, and I think it's warranted.
Why didn't you email the lead lawyer on the case?
Because the lawyer that scheduled the mediation with us was the one. So there was a chain of emails, and the only one that was corresponding with us about scheduling the mediation was not the lead lawyer, I guess. And so that's the person that I reached out to once nobody showed up.
And in response to that, Judge, I think it's Exhibit 1 to our response. You can see in the email chain, I was the one originally talking about mediation. I'm the one who agreed to use Jeff Jury. And then subsequently to that, Mr. Karamitas' office took me off the chain. And then my associate then requested that I be added back in. Also, to the point on the mediation order, there was not an order to mediate in this case. We did end up entering into a agreed scheduling order. I think it was a couple months ago. It was after this mediation had apparently originally been scheduled. And I think there's a February 2024 or 2025, excuse me, mediation deadline. Like I said, we worked with Mr. Jury. We've got another mediation scheduled, and I think it's 2 weeks now. It's on November 7th.
Okay. All right. A couple of things here. Best practice, copy everyone on the case. Period. I think the requirement under the rules, whoever signs the pleading that's on file is the lead counsel. And then on the flip side, anybody who receives an email needs to be sharing it with your entire team, Ms. Glazer. You know, I mean,
I understand.
your associate definitely made a mistake in not doing that, but I don't think this rises to sanctions at this point in time. I think there's room for both of you to do better, and good luck on your next mediation.
Okay. Thank you, Judge.
All
Maybe
right, y'all are excused.
Thank you,
you.
Judge.
Bryant versus State Farm. And
Good afternoon, Your Honor.
good afternoon. All right.
May I proceed, Your Honor? This is my
You-
motion for continuance.
You may, and I did
Uh,
read both the motion and the response, so
Okay.
I'm a little bit acquainted with your situation.
Yeah. So, Your Honor, this is unfortunately, and I don't think any of this is disputed. Charlie and I didn't communicate the best. This case was originally set for trial, I guess, back in April. It's a UIM case. Plaintiffs wanted to depose the claims rep. The trial court granted that. We filed a mandamus on that regarding whether or not they were entitled to that. That was back in December, and the parties agreed, yeah, we got to move this April 2024 trial date. And at Mr. Dunn's appellate counsel's suggestion, he said, look, why don't we just abate the mandamus as well? Because this same issue is in front of the Texas Supreme Court. Let's wait for them to give us an answer. So that made sense. So we look for another trial date, and included in my motion, Your Honor, is the email chain that has all the communications. And so back on March 13th, Mr. Dunn's firm asked if November 4th, 2024 would work. That's the current trial date. So back in March of this year, they asked, and we said, yeah, back in March, November 4th, 2024 will work. So we agreed to that. I never got notice. I never heard back from them. So on June 14th, so March, April, May, June, I sent another email to Mr. Dunn, and this is on Bates labeled the email chain, Your Honor, but this is State Farm 6. And this is an email I sent to Mr. Dunn on June 14th. And I said, hey, have we reset the trial in this case yet? And said, we have this mandamus, how do you want to handle it? He responded that same day and said, no, hasn't been set. And he said, look, we'll just waive the deposition. Let's go ahead and the case needs to be tried. And I said, okay. But he said June 14th, case had not been set. So sometime after that, Your Honor, I don't know exactly how long after that, I took that hearing or that trial off my calendar. And my daughter, who lives in LA, is moving the week of November 4th. And I scheduled a trip to be out of town in LA with her. So after I sent that email in June saying, hey, or after Charlie responded to my email saying, no, it hasn't been set for trial, I followed up July 25th and said, well, hey, what dates do you want for this trial? Let's go ahead and get it set. He responded the next day and said, oh, it's set for November 4th. And I said, I never received notice of that. Can you please send that to me? And his legal assistant, Joe Lobmeyer, sent that to what she sent to the court, and it's the very last page. And she did, in fact, go to the civil calendaring online and get a reset for this trial, setting it for November 4th, 2024. And she did that back on March 14th, the day that we had originally said, yes, we're available for trial. But that was never sent to us. I asked Ms. Lobmeyer to see if that had been sent to us. And if this is Bates labeled as State Farm 8, Your Honor, and it has the online notice that Ms. Lobmeyer sent to me when I inquired in July, saying, hey, I don't think I ever received that, and it's not on my calendar anymore. And so she sent it to me. I'm not included on it. I followed up with her and said, can you please let me know if you have this, because I don't. So anyway, she has not provided that to me. So apparently it was set when we originally discussed it in March. I never got notice. I followed up with Mr. Dunn. I said, is it set? He said no. He made a mistake, just like we all do. And then I followed up in July saying, let's get this thing set. And he said, oh, well, we are set. We're set November 4th. So anyway, Your Honor, just because of that, I do have a absence of counsel as my reason for not being able to attend the trial. I agree with Mr. Dunn. This case does need to be tried. I have proposed several dates that are in my motion that I'll be available for trial: January 27th, 2025, February 10th, February 24th, and March 24th. And Mr. Dunn has indicated to me that he's available on the January 27th, 2025 date. So because of that conflict, Your Honor, and the confusion on getting this set, I'm asking for a continuance, a brief continuance, so we can get this case set, so we can get the mandamus taken care of, because it's still abated, it's still pending, but it's moot because Mr. Dunn says he's not going to be pursuing the claim rep's deposition anyway. And Your Honor, if I understand that one of the plaintiffs, Miss Michael, when I took her deposition, she was living in New York. I understand she might still be living there. To the extent, if she's already bought a plane ticket for November 4th, I'm willing to reimburse whatever the reasonable cost of that airfare is, just to take my share of responsibility for this mess up. If she's not going to be coming November 4th, because I understand the other plaintiff, Miss Bryant's a friend of hers, but assuming she's not going to be using that ticket, I'll reimburse the reasonable cost of that. So based on that, Your Honor, we're just asking the court to grant our motion for continuance, then reset it January 27th, if that's available, or a time when it's mutually convenient for all parties.
Okay, Mr. Dunn.
Just a few points, Your Honor. It wasn't the claims rep we're trying to depose. It's actually the corporate representative that State Farm doesn't want to pose. The case was set after we agreed that it wasn't economically feasible on a personal lines $250,000 UIM policy car wreck case that should take 1 day of testimony, half a day of voir dire, and another half a day to put a jury charge together and get a verdict. This case was originally filed back in September of 2022. It was set for trial in April of 24. It would have gone to trial, but for State Farm using their economic leverage and ability to file mandamuses to prevent a corporate rep who is the company representative for the insurance company from being deposed. Even though there's a lot of case law that says they can be deposed on limited subjects. Neither here nor there, we won the hearing at the trial court, and they had exercised their right to mandamus and delayed the trial. That being said, the real issue is, regardless of the miscommunication issues, the email issues, and who this setting was sent to at his firm and who it wasn't sent to. That's really not the real issue. The issue is he's had 15 weeks notice. He admits that he knew in July, the last week in July, that this case was set on that week. So the issue is, can you get a case ready in 15 weeks? It's a simple car wreck case that has no real complicated issues, and discovery's done. And is your daughter's move more important than my client who's already waited 2 years from the date of the jury trial to go to trial? The next issue that's really important is it won't get reached in January. If we reset it this late on the Travis County docket, we'll be so far down that they try 4, maybe 5 cases on that docket to get 2 or 3 passed. And so if you're lower than 7 you're going to be on the I'm not going to get reached list. So then we're looking at how many more months to get a reset. Bottom line is, this is an incredible hardship to my clients, and there's no reason for it. This case is quick, easy, simple, and if it weren't for the Brainerd Supreme Court ruling, this case would have already been either Stowers and a little pressure put on State Farm, or it would have been settled. That's all I have to say, Judge.
All right. Mr. Brown, any final remarks?
Well, Your Honor, as far as Mr. Dunn point that, yes, this is an easy case to try. It is. The problem is I now have a conflict because I was affirmatively told in June this case isn't set for trial. So I went ahead and took it off my calendar. I agree with them. I wish I could. And Your Honor, if it matters to the court, my daughter is having some health issues. I'd be more than happy to go into that. I would rather not do it on Zoom if the court thinks that's relevant. At any rate, but it's just because of the conflict, Your Honor. I understand the delay. However, I think Mr. Dunn and I both need to share responsibility for this and get this case set so we can actually get it tried.
All right, let me ask a couple of questions here. So, Mr. Dunn, back in the early summer, when Mr. Brown said, "Hey, is this set?" Why didn't you tell him that it was set in June, if in fact it was?
I made a mistake.
I don't understand that. Okay.
Lawyers make mistakes. I
Yeah.
made a mistake. I should have checked with my paralegal, and I should have checked the online calendar just like Mr. Brown should.
And do you know why your legal assistant didn't send the notice? If she in fact set it in March, why wouldn't the notice have been sent in March?
Well, it was on the online calendar, and I think she assumed notice would automatically been sent out. And Mr. Brown had agreed to that date. And so, to be honest, we don't generally resend those notices. Once they're put on the calendar, that's public notice to all the lawyers. So
Well,
I
it
don't know this
doesn't
for
sound like that is the case at all, unfortunately. I don't think the rules speak to online county calendaring systems. I think the rules require, 45-day notice of a trial setting is the minimum. But anyway, I just
Well,
don't
it was an agreed trial setting, and but the bottom line is, I don't know this for a fact, but there was a previous attorney that had the case before Mr. Brown from his same law firm, and the email could have been sent to him, but I didn't check on that, and I don't have a copy of it.
Okay.
Your Honor, if I can respond to that, the email that was sent, if you look at page 8, or what's labeled as State Farm 8, that's the email from the court and it's sent to Joe Lobmeyer, who works for Mr. Dunn's office, Mark Pierce, I'm not real sure who he is, P. Marshall, Charles Dunn, Charlie Dunn, Joe Lobmeyer again, Mark Pierce. Wasn't ever sent to me, and it wasn't sent to my legal assistant or to any other attorney in this firm. And even if it were, Your Honor, I asked him in June if it had been said, and made an honest mistake. He said no, it hadn't been.
Okay. Let me ask you, Mr. Brown, is there anybody else at your law firm who can step forward and try this case?
Your Honor, I do not think so. We only have, it's me and Lisa Michaud. We are the only attorneys who are litigating files. I have not checked on her availability to see if she is available. However, she has not worked on this case. It is a little bit more complicated than what Mr. Dunn indicated. There are two plaintiffs. There is extensive medical, one of them surgical recommendation, pre-existing injuries, issues about reasonableness, necessity, and attorney's fees in these UIM cases, which is now an issue in all of them. So asking Lisa to come in and handle this, even if she is available, Your Honor, I don't think putting her in that position is really possible.
Okay. All right. Have either of you picked up the phone and talked to Mr. Barbara about what it looks like for you either in November or in January, just out of curiosity?
I have not, Your Honor. Charlie, I think Mr. Dunn can speak to this. I think he might have checked or might be thinking of another case.
No, I have not. I think
Okay.
the docket comes out Friday.
Oh, sure. All right. Well,
And Your Honor, I did provide a Word version of a proposed order. And I sent that to Ms. Seeger yesterday, so the court should have that. I just left a blank there on setting it on a date certain or just a future date mutually convenient to the parties.
all right. Well, I am going to go ahead and grant the continuance. But what I am going to request that you do is contact Mr. Barbara's office. He or someone in his office can better advise you. I do fear that what Mr. Dunn said about January could be true. However, the keeper of that information about whether it is or isn't true is Mr. Barbara. And he may or may not be able to provide some guidance about these various other options as far as resetting it. So for now, I will grant the motion for continuance. I'm going to request that counsel, one or the other of you, reach out, get some guidance, and confer about what date makes the most sense in light of the fact this is a 2022 cost number. You need to get reset and reset on a date where you're going to be able to go. Make sense?
Yes, Your Honor. We'll go ahead and contact Warren, Mr. Barbara, and start that process.
Okay. When you have a new date identified, if you want that to go in the order and you get this figured out today, reach back out. Otherwise, I will just grant the continuance.
Very good, Your Honor. And should we reach out to Ms. Seeger or to Mr. Woodby?
Either is fine.
Okay.
They both know where to find me.
All right. Thank you, Your Honor.
All right.
They would be excused.
You are excused.
All right.
Thank you. So we have Johnson and Fields. All right. Next. All right. And just give me a moment to get over to that file. All right. Okay, Miss Reynolds.
Your Honor.
So I guess I looked through this file to try and find what was set today because the docket says motion to dissolve. And of course, there is no motion by that name in the file. So I think you told me you're
Well,
amending a judgment. What's going
yeah.
on here?
Well, under the system, that's the only thing I thought could be close to an entry, and that's what I want, entry of the final judgment. I did need to amend it, which I sent the amendment this morning, amended final judgment to Ms. Seeger and Mr. Woody, because in the one that was signed on October 3rd, it had the comma in the wrong place, so the figure wasn't right. So I just want an entry of the amended final judgment.
Give me a moment here. So what comma are you talking about? I guess I need to understand.
Past medical number 1 listed as the amounts. It has 10, comma 00.00. It should have been 10,000.
Okay, and what is the date that was entered? You said it was
3rd, 2024.
okay, here it is. Oh, so you're missing a 0. I
Correct.
see. Should this be a nunc pro tunc? Is this a clerical error?
It could be if I need to do that. I just realized it. Well, I just realized it yesterday, but if I need to do that, I'm willing to do that. Since we were already set for today,
That's fine. I think it's fine to do it the way you're doing. I'm just asking a question. Let's see. So you were in front let's see. Judge Connor earlier this month.
Yes, and there's court said she's no longer signing submission orders.
Okay, so and that's the only item that's being changed from the final judgment entered on the 3rd versus what you're presenting the court today. Is that 1-0?
Yes, ma'am.
Okay. All right. Well, I don't have any questions for you. Since this just happened on the 3rd, I don't have any concerns about plenary power or anything. So I will take care of it with entering the amended final judgment and send that over to the clerk's office.
Okay.
All right. Thank you, Ms. Reynolds. You're excused.
Thank you. God bless you. Bye-bye.
Take care. Guerrero and Barnett. Okay. Last but not least, sorry to keep y'all waiting. And
Your Honor.
yeah.
Hello, Judge.
Hello. And Neil said no record, so who wants to take the lead on this one?
I'll defer to Mr. DeShazo if that's okay with Ms. Wyatt.
I'll defer as well. Thank you.
All right, Mr. DeShazo, you have the floor.
Okay, thank you. Ms. Guerrero, will you tell us your full name?
Rebecca Guerrero.
Okay. And your daughter, Giselle Esparza, was involved in a car accident back on October the 1st of 2023. Is that correct?
Yes, sir.
And you were not at fault for that accident. Somebody else was. Is that right?
Yes, sir.
Okay. And you've made a claim against that individual who caused the accident that your daughter was injured in. Is that right?
Yes, sir.
Okay. Now, your daughter had mainly soft tissue type injuries, correct? She didn't have any broken bones?
That's correct. Yes, sir.
Okay. And she underwent a course of treatment with physical therapists and had some imaging done and some emergent treatment. Is that right?
Yes, sir.
Has she fully healed from her injuries?
Yes, sir. She is.
And she plays competitive softball. Is that right?
Yes, sir. She does.
And what year is she in school right now?
She's currently a junior.
Okay. Is she being recruited by people to potentially play softball in college?
She is getting emails and visits set up currently.
Is she back to full speed in your estimation?
Yes, sir. I would say.
Okay. Now, have you been able to see a breakdown of the settlement that is being proposed?
Yes, sir. I have.
You understand that it's a total of $50,000, and attorney's fees make up about a third of that, or 16.5 payable to your lawyers. You understand that?
Yes, sir.
And then there's some medical expenses that are also being paid out of the settlement. You understand that?
Yes, sir.
You understand if any medical expenses are outstanding after the payment of the ones that have been agreed to, that you'll be responsible for those.
Yes, sir.
Okay. Do you understand that $23,012.82 is going to be placed into the court bank account for the benefit of your daughter?
Yes, sir.
You understand that when she turns 18, that she'll be able to go get that money out of the account and use it how she wishes?
Yes, sir.
You understand you won't be able to get to that money?
Yes, sir.
All right. You understand that if you agree to settle this case, that you will not be able to make another claim on your daughter's behalf against the at-fault driver?
Yes, sir.
If you agree to settle this case is over once and for all. Do you understand that?
Yes, sir.
Have you been told that you have the right to go to a jury trial if you so choose, and perhaps the jury might award you more money?
Yes, sir.
Okay. And despite that, do you believe that this settlement is in your daughter's best interest?
Yes, sir.
All right. And what are you asking the court to approve it?
Yes, sir.
All right. Thank you, Ms. Guerrero. I'll pass the witness.
All right, Mr. Gonzalez.
Just a couple of questions. Rebecca, how are you?
I am fine. How are you?
And, Mr. DeShazo was very thorough in his questions, but you completely understand that once this is done, it's done today, correct?
Yes, sir. I understand.
And the big important question is, has Giselle picked the school she wants to go to yet to go play softball?
She has not. She's still going on visits.
Well, good. Well, good for her. I wish her well. Thank you, Judge. I'll pass the witness.
Okay, Miss Wyatt.
I just have a couple questions, Ms. Guerrero. Do you understand that once your daughter does pick the school, and if she starts having any complications or anything, she can never come back and recover for this same accident? Do you understand that?
Yes, ma'am. I understand.
Okay. I have no further questions. I'll pass the witness.
All right, Miss Guerrero, I failed to swear you in earlier, so let me just ask, is everything you've told us here in the courtroom this afternoon the truth?
Yes, Your Honor, it is.
Okay, and you think that this settlement is the best decision for your daughter?
Yes, Your Honor.
Okay, and you're asking me to approve it?
Yes, Your Honor.
Okay. And Mr. DeShazo, I missed this. Is it going to be an interest-bearing account?
Yes, Your Honor, it is.
Great.
And that is stated in the proposed judgment.
Okay, and we're taking care of the guardian ad litem fee as well?
Yes, Your Honor, the defense is paying that.
Okay. And how much are we paying for that fee?
I think it's 15.
That's correct. Yeah.
1,500? Okay. And I just want to confirm that the attorney's fees are a third of the total value of the settlement.
That's correct, Judge.
Okay, great. All right. After having heard the testimony and having heard from the guardian, I have no further questions. I will approve the settlement, and we'll get that signed and sent to the clerk's office. Best of luck to your daughter, Ms. Guerrero. Hope she goes to play softball wherever she wishes.
Thank you, Your Honor.
Glad she has recovered. All right, counsel, thanks for your patience, and seeing nothing else, y'all are free to go.
Thanks, Judge.
Thank you, Your Honor.
Have a
Thank
good
you.
afternoon,
Take care.
everybody. Okay.